In this video, we're going to be looking at the question of when do constructive trusts arise? So, in other words, how do we determine a constructive trust? Despite definitions of constructive trust as arising in circumstances of unconscionability, they actually arise in a wide variety of circumstances. Okay? There is no requirement for the legal owner to have acted in any way dishonestly or discreditably. It is not dishonest to be paid money by mistake. It may be unconscionable to keep the money after the mistake has been brought to the attention of the recipient. So there doesn't have to be any dishonesty, fraud, or knowing receipt. It could be just a simple mistake. So for example, in Paragon Finance, Millett did attempt a general definition of the constructive trust, and he said a constructive trust arises by operation of law whenever the circumstances are such that it would be unconscionable for the owner of the property, usually but not necessarily the legal estate, to assert his own beneficial interest in the property and deny the beneficial interest of another. The breadth of principle explains why the constructive trust is likely to continue to grow, as is considered in a second in this video, in relation to the decision of the House of Lords in the Landesbank case, where the constructive trust will arise in any situation in which the title holder of property is unconscionably denied or interferes with the rights of another. As such, it is clearly a principle of potentially very broad application. So let's look at the common circumstances giving rise to a constructive trust. And I'm essentially going to go through this whole list over the next few videos. And today we're going to mainly focus on breach of fiduciary duty and mistake. Okay, so let's get started with the breach of fiduciary duty. Now, this is pretty basic and easy to understand. Constructive trusts are the major remedy for the breach of a fiduciary duty. The constructive trust that arises in response to a breach of fiduciary duty is institutional in that it arises on the occurrence of the breach and not the court order. So yeah, do make sure you check out my video on this. I have a video on the difference between an institutional and a remedial constructive trust. And I've also got videos on fiduciary duty, so check out all of that if you're not too sure about that. Okay? And we've also previously discussed these two cases here, which are Keach and Sanford and Boardman and Phipps. Okay? So in Keach and Sanford, the rule that the trustee of a tenancy who obtains a right to renew that tenancy holds that renewal on constructive trust for the beneficiaries. So if a fiduciary earns unauthorised personal profits from her fiduciary office, then she'll be obliged to account for those profits. In the first place by means of a constructive trust imposed over the profits, or if the profits cannot be identified, that will be by means of a personal account to the trust. Now, the purpose of this principle is to prevent fiduciaries from permitting any conflict between their personal interests and their fiduciary duties. The rule that a fiduciary cannot take an unauthorised personal benefit from her fiduciary office then emerged from this case of Keach and Sanford, in which the benefit of a lease with rights to receive profits from a market was settled on trust for an infant. So in this case then, the trustee Sanford sought to renew the lease on its expiry, but his request was refused on the ground that an infant, Keach here, could not be bound by such a lease. Therefore, the trustee sought to renew the lease in his own name with the intention that its benefits could then be passed on to the infant. As such, the trustee was benefiting personally, although purporting to act in the interest of the beneficiary by use of a right not available to the beneficiary or the trust. The court held that the property was held on a constructive trust for Keach, as it is unconscionable for Sanford to benefit here, as he would be taking an unauthorised personal benefit. And then in the case of Boardman and Phipps from 1967, the House of Lords held that a fiduciary held shares on constructive trust because the opportunity and information to acquire them came to him by virtue of his position. So the trustee held a minority shareholding in a private company which was not being effectively managed. Boardman had acted as a solicitor for the trust and was therefore a fiduciary. he decided that the beneficiaries would be in a better position if the trustees had control of the company, but no money was available to buy these extra shares. So Boardman and one of the other beneficiaries therefore bought the necessary shares themselves and reorganised the company. And all of this was done in good faith and with the objective of enhancing the trust holdings. So subsequently, both the personal and the trust holdings increased in value. Nevertheless, a majority of the House of Lords held that Boardman was a constructive trustee of the profit made on his personal shareholding. The opportunity to make the profit arose out of his fiduciary relationship with the trust, and certain confidential information had been shared with him and used in that process. But despite that, compensation was still ordered from the trust in recognition of the work and skill involved in managing the trust. So secondly, we have mistake. So if by mistake the plaintiff conveys title to the wrong person, or the wrong property is conveyed to the intended person, or the plaintiff is otherwise induced to act by reason of mistake, that transfer can be set aside. So let's explain this by means of a case. And we've got Chase Manhattan and Israel British Bank from 1981. So here money was transferred to the defendant bank by Chase Manhattan. By mistake, a second transfer of the money was made. Before the mistake was identified and the money repaid, Israel British went into insolvency. So there is a mistakenly made payment that everyone wants a part of now due to the fact that the defendant went into insolvency. In such a situation, anyone owed money by the insolvent bank is much better off if they can establish that specific money was held on trust for them. Such money will not be included in the assets to pay off all the other unsecured creditors. So if you can establish a constructive trust over the money, you will have a better claim for the money over other creditors. Now, it was eventually held that there was a trust over that money. And then we've also got this case of Westdeutsche Landesbank and Islington from 1996. Now, according to the principles set out by Lord Brown Wilkinson in this case, a constructive trust could not have arisen over the second payment in the previous case until Israel British became aware that the second transfer was a mistake. So Lord Brown Wilkinson here is saying that a constructive trust could not have arisen over the second payment in Chase until the receiver had noticed the mistake. So you have to know you have the property in order to become a constructive trustee of it, according to Lord Brown Wilkinson. He held that where money was paid under a mistake, the receipt of such money, without more, constituted the recipient, a trustee. He said that the payer retains an equitable property in it, and the conscience of the recipient is subjected to a fiduciary duty to respect his proprietary right. It will be apparent from what I have already said that I cannot agree with this reasoning. I cannot understand how the recipient's conscience can be affected at a time when he is not aware of any mistake. Okay, so what Lord Brown Wilkinson is saying is that Chase is wrong for creating a constructive trust because the recipient didn't know they had the property. He says that in order for it to be unconscionable, and for it to be unconscionable to actually have something, you must know you actually have it. So it requires that extra step of logic and knowledge. Okay, so I'm going to leave this video here because it's getting a bit long, but in the next video we're going to continue, and I think we're going to focus mainly on mutual wills. But if you have any questions at all about this video, then make sure you leave a comment or question below and I'll try to get straight back to you. And then if you enjoyed the video, make sure you give it a thumbs up and subscribe to my channel. Thank you very much for watching.